Hello, this is Attorney Brian Pendergraft, and this presentation is on real estate contracts for investors, understanding both buyers and sellers' position, and how contracts clauses can help support your position, whether you are buying or selling investment properties. And you can download the slides to this presentation by visiting www.tpf.legal/rek. Disclaimer: this is legal information, not legal advice. For legal advice, please contact an experienced attorney in your jurisdiction. Introduction to real estate contracts for investors. Real estate contracts can be drafted in a way to help real estate investors achieve their goals, whether they're buying or selling investment properties. By understanding buyers' and sellers' position, one can tell what clauses in a contract works to his or her advantage. Real Estate Contract 101, the basics. At minimum, a real estate contract must identify the parties, describe the property, clearly define the terms of payment, contain an offer and acceptance, also known as a meeting of the minds, a mandatory and contain mandatory federal clauses such as lead paint clause, perhaps a VHA loan clause if there's a VHA loan. And they should contain mandatory state-specific clauses. For example, many states require that sellers disclose the hidden defects in the property. If everyone just used the minimum of what is required, then most real estate contracts could be done in one page. However, most clauses inside of a contract benefit the buyer or the seller in one way, in some way, which is why most contracts are well over one page. Understanding buyer's position. When buying investment properties, the goal is generally to buy the property at a discount or on great terms, earn a profit, avoid legal liability, and to minimize risk. And when selling an investment property, the goal is generally to maximize profit, avoid having non-serious buyers tie up the property, sell fast, and to minimize risk. Buyers versus sellers position. So the positions are often adversarial. A clause that often benefits one side is to the detriment of the other. Starting with down payment and escrow clauses. A down payment is used as consideration for a real estate contract. It's generally money that will be held in escrow and credited to and applied to the purchase price. Buyer's position on down payment and escrow clauses. Remember, the goal is to minimize your risk of losing money by paying a small deposit or no deposit at all. And you can do this by you can pay a small deposit that is held by a neutral party. If it's held by a neutral party as opposed to held by the seller, that if that increases your chances of getting it back than if the seller held it. You can use a promissory note that is payable at a later date instead of putting money down. Or instead of putting money down, if you don't have any money, you can pay using a good or a service, or you could pay with a deposit, and then you can make the deposit returnable to you even if you default, and most sellers won't accept that position. All right, seller's position on down payment and escrow clauses, and you want to do just the opposite. Your goal is to make sure you get a serious buyer that you are compensated for taking the property off the market if the buyer does not go through. So you want the buyer to pay a large deposit that is forfeit if they do not perform, and if it's possible, you can hold the down payment yourself or have your attorney hold the down payment. Assignment clauses. An assignment clause allows the buyer to sell his or her contract to another buyer and be relieved of the obligations. The seller and the substitute are bound to the original contract. Buyer's position on assignment clauses. So if you're a wholesaler and you're selling the rights to the contract for profit, you absolutely need an assignment clause. If you're buying to hold, it doesn't really matter. Seller's position on assignment clauses. So the goal is to find a serious buyer and to maximize profit. chances are you have a better chance of finding a retail buyer or someone who's really interested in the property if the contract is not assignable. Or if you do make the contract assignable, then you should make it consider making it assignable with your approval after you verify the assignee's ability to purchase, because they can just assign the contract to anybody, so they may not necessarily assign it to someone that you believe has the ability to go through with the contract. So keep that in mind. Assumption versus subject to. In an assumption or subject to deal, the buyer agrees to take over the mortgage payments. And in the assumption, the buyer agrees to take on legal responsibility for the mortgage. In a subject to, the buyer does not agree to take on legal responsibility. So if you're a buyer, you want to minimize risk by using a subject to. And if you are a seller, you want to minimize risk by using an assumption, because you want them to be held legally liable if they do not pay. All right, so there are all sorts of what I call tie up the property clauses that let a buyer or seller back out of a contract even after putting the property under contract, and effectively kind of ties up the deal, ties up the property. So an investor buyer wants to be able to get out of a deal last minute if they need to. And investor sellers want committed buyers that cannot back out at the last minute. Financing contingencies. So a financing contingency allows a buyer to back out if they cannot get funding. Now, this is necessary for most deals. All right, so seller's position on financing contingencies. So again, financing contingencies often cannot be avoided. However, they can be limited. So the seller wants the ability to avoid the contract if buyer cannot get financing within a certain amount of time to prevent their property from being tied up. Remember, the goal is you want to be able to move on as soon as you can to other buyers if they're not, coming through. So you can get that house sold. So buyer's position on financing contingencies. So again, mandatory if a buyer needs funding, and no time limit or a longer time limit to get your funding favors the buyer. So the goal here is to give yourself enough time to get money or to back out of the deal if you can't get it. Owner financing. So owner financing is when the seller agrees to hold the note instead of the buyer using a lender. Owners can often hold the note at a better rate than banks. That is a music note. Get it? Hold the note. Buyer's position on owner financing. You want to minimize risk and to maximize profit. So you want a long grace period for missed payments. You want the buyer wants the right to assign their interest and no prepayment penalty if they paid sooner. Seller's position. So if you're holding the note, the goal is to make sure you get paid. So you want to kind of act just like the same way a lender does. You want a short grace period. You want it to be not assumable, or if it is assumable, then calculated at a higher rate. And just like lenders, you want a due on sell clause. So again, you want to protect yourself. Think like a lender. All right, due diligence clauses. So there's many different clauses that allow a buyer or his inspectors to inspect a property to make sure that it is in good condition, or allows the buyer to examine records such as existing lease or condominium documents. Examples of due diligence clauses include termite clause, title evidence / defects clause, plumbing and electric, survey, radon, existing leases, ingress and egress, restrictions and easements, condominium docs, roof, make sure the roof's in good condition, violations, engineering report, and zoning. It's probably more too. Buyer's position. So when you're buying a property as is, the goal is to get the property in great condition. So if defects are found, buyer wants a clause that gives you the option to fix the defects at the owner's expense, or to reduce the purchase price, or to back out of the deal entirely. And the buyer can also save money by trying to push inspection costs to the seller, However, I think most sellers probably push that cost to the buyer. That's probably how it plays out usually. Seller's position: if you're not selling the property as is, you want the ability to extend the contract for X number of days to fix any issues that may show up, or you want to be able to back out of a deal if you feel as if the cost to fix the issues are too expensive. And seller can also save money by pushing inspection costs to the buyer. Seller's position continued. So the last thing a seller wants is for a buyer to back out on the day of closing. So sellers should limit the buyer's time to do their inspections or to approve documents such as leases and condominiums. You want to limit the amount of time that a buyer can do their due diligence. Otherwise, they could back out at the last minute. Expense clauses. Expense clause says who pays for termite inspections, surveys, closing costs. Either party can try to push some or all the costs to the other side, or they can split the costs equally. Prorations clause. A prorations clause is used to prorate taxes, rents, interest, and property owner dues at closing. This generally favors the buyer. A seller can attempt to avoid prorations by factoring it into the purchase price. Third-party approval clauses. So a third-party approval clause allows a buyer to back out if the contract is not approved by a third party. Examples of third-party approval clauses are subject to the approval of my partner, my spouse, my real estate coach, or my favorite one, subject to the approval of my attorney. All right, seller's position. So on third-party approval clauses. So the goal is to lock in a committed buyer that will not back out at the last minute. So an investor seller wants to either eliminate third-party approvals or make sure that any third-party approval that they allow is for a legitimate business reason. For example, subject to approval of my partner can either mean A, you're really dealing with a partnership that can only be bound by approval of that partner, or B, a phantom partner that the buyer uses to back out of deals. So some people won't do business unless their contract is reviewed by an attorney. So they may have a legitimate reason to use a subject to the approval of my attorney clause. So if a seller allows for a third-party approval, they should limit the amount of time that the buyer has to approve to prevent the buyers from backing out at the last minute. On the other hand, if you're a buyer, again, your goal is to minimize risk, so use third-party approval clauses liberally if you can. And if you need an attorney to approve your contracts, and if you're in the Maryland or DC area, do not hesitate to contact me. Yes, that's a plug. Get it? There's a plug photo. Maintenance clauses. So maintenance clauses are generally used to make sure that property is delivered in great condition. They usually contain things like no holes in a wall, lawn cut, broom clean condition, walls watch, etc., etc. So if you are the seller, this clause really has no benefit to you. Sellers generally sell ugly houses as is, or when selling pretty houses, the seller wants to limit the amount of time a buyer can back out of the deal due to maintenance issues to avoid buyer backing out at the last minute. On the other hand, if you're a buyer, unless you're buying the property as is, you want the property delivered in pristine condition. I mean, you can put something in the contract, you can subject to your approval 24 hours before the closing date if you can get away with it. Moving on to risk of loss clauses. A risk of loss clause determines what happens if a property under contract is destroyed before the closing date. So if you are investor sellers, want to be able to extend the contract and fix the issue or back out of the deal if restoration costs are too expensive. On the other hand, if you are the buyer, you want to be able to buy the house as is and take the insurance proceeds to restore the property, or you want to be able to back out of the deal. Default clauses. A default clause are the consequence if a buyer or seller does not perform. As the key example, or the best example I can think of, is if the buyer ends up not buying the property, or if the seller ends up not going through the contract and deciding not to sell the property. If buyer defaults. So the super investor buyer friendly position is the buyer gets his earnest money deposit back and the contract is voided and there are no other remedies. Yeah, good luck getting this in your contracts. Some of the neutral position is if a buyer loses his earnest money deposit as liquidated damages, and then there are no other damages. So buyer just loses his money that he put up. And the investor seller position is that you want the buyer to lose their earnest money deposit, and you want to maintain the right to sue the buyer for specific performance, which would be the court ordering him to buy the property, enforcing the sale. If a seller defaults, as if you are the buyer, the investor buyer position is you want your earnest money deposit back and you want to maintain the right to sue for a specific performance. On the other hand, if you are the seller and you default, you want the default clause to be that you just return the buyer's earnest money deposit and no other remedies. Possession clauses. So possession clauses are used to determine a buyer's remedy if a seller cannot deliver possession by the closing date due to the seller's fault. So if you are the investor buyer, you want possession at the closing date or compensation for any delays caused by the seller. It's usually done by a dollar amount per day, say something like $50 per day. On the other hand, if you're a seller's position on possession clauses. So if there is a situation that prevents the buyer from immediately taking possession, such as existing tenants on the property, you want to make it clear that you have agreed to not deliver possession at the time of closing, and that they are buying the property with tenants on the property or whatever's there, or squatters, whatever it may be. Lien affidavit. So a lien affidavit is a sworn statement that there are no liens on the property, and this is generally required by a closing agent. So if for the buyer's position, you definitely want a lien affidavit to hold the seller liable if there are undisclosed liens. And if you're selling, again, lien affidavits are often required. However, do not represent that there are no liens on the property if there are liens on the property. Arbitration clauses. And arbitration clauses are used to make parties go to arbitration before or instead of going to court. Arbitration can be binding or non-binding. Generally, arbitration is cheaper than going to court. More on arbitration clauses actually. So it's hard to tell whether an arbitration clause, benefits either investor buyers or investor sellers. So, just definitely, think about it. But again, if you want to save money, arbitration may be better than going to court. Attorney's fees clauses. So attorney's fees clauses are used when if the parties end up suing each other over the contract. So they come in two different flavors. So there is the prevailing party clause, meaning that if you go to court and the losing party pays for the prevailing party's reasonable attorney's fees. And then there is the own fees clause, which each party pays for their attorney's fees no matter what the outcome is, regardless of whether you win or lose. You still pay your own attorney's fees. You do not pay the other side's attorney's fees. So whether or not an attorney's fees clause benefits the buyer or seller depends on the situation. If you have the best attorneys on the retainer, you may want a prevailing parties clause. Which brings me to my next point. You need a real estate attorney for investors. You can contact me, Attorney Brian Pendergraft of the Pendergraft Firm, LLC, and I can help you buy preparing real estate contracts that protects you when buying investment properties. So preparing real estate contracts to protect you when selling properties. I can do a third-party approval or review of your real estate contracts, and I provide real estate law services for investors in general. And how to contact me, Attorney Brian Pendergraft. So you can contact me through my Facebook group, Planlord. So you can Facebook Planlord, search it, you'll find me. You can find me on Instagram, Twitter, Facebook, or YouTube at Pendergraft Firm. You can call my office at 301-200-0777, or you can shoot me an email at info@tpf.legal. Or you can schedule a phone consultation at bookme.name/attorney. And that's probably the best way to reach me, is to schedule a phone consultation, leave your phone number, and then I'll call you at a time that works best for you. Thanks for watching. And remember, you can download the slides at tpf.legal/REK. If you're wondering what REK stands for, RE stands for real estate and K stands for contract. And again, thanks for watching. Take care.